A quorum being present, the committee will come to order. Today we're meeting to consider a committee print extending the Department of Homeland Security's Chemical Security Authority. I now recognize myself to make an opening statement. The accidental release of 40 tons of methyl isonate from a chemical facility in India killed 3,000 people initially, and at least 15,000 more have died from related illnesses since the accident in 1984. A similar situation could result from the intentional release by terrorists. Chemical facilities are a known terrorist target and must be protected. In both this Congress and the 109th Congress, the committee held several hearings on the topic, including 2 in this subcommittee in 2007, and last year we marked up and reported H.R. 5695, the Chemical Facility Anti-Terrorism Act of 2007. Unfortunately, this legislation did not become law. However, Congress granted such authority in Section 550 of the Homeland Security Appropriations Act of 2007. Pursuant to this law, the Department promulgated the Chemical Facility Anti-Terrorism Standards, CFATS, which was issued in June of 2007. However, OMB held up the release of the covered chemicals list, called Appendix A, until 2007. So effectively, the regulations have only been in effect for 2 months. The Department did proactively reach out to roughly 100 companies that they were sure would be captured under the regulations and asked them to begin the regulatory process by completing a top screen questionnaire that lists the chemicals held on site by these facilities. Most other covered facilities have just begun the top screen process. The regulations are required to be risk-based and performance-based. The Secretary is required to place those facilities that are regulated into one of 4 risk tiers. The highest risk tier will have the most stringent security performance requirements. This gives a facility an incentive to close safer practices, to choose safer practices, and move to a lower risk tier, which would then allow them to spend fewer resources on security. This committee does not want to reinvent the wheel, but we believe that the fundamental approach taken under CFAX is the correct one. The committee intends for the bill under consideration to extend and make permanent the CFAX regulation with some modification. Current CFAX regulatory authority sunsets in October of 2009. This bill would phase in as the current CFAX expires, which will ensure the smoothest possible continuation. While most of the bill will simply statutorily codify CFAX, the bill will make several improvements in future implementation. Currently, CFAX exempts water treatment facilities regulated under the Safe Drinking Water Act and port facilities regulated under the Maritime Transportation Security Act. This bill does not have such an exemption and calls for the CFAX to work smoothly with the existing authorities. The bill makes a stronger promotion of lowering of site consequences than current law by requiring a facility to consider practices to reduce those consequences as part of the SSP. And in the case of high-risk facilities, the Secretary may require implementation of those practices if feasible. The bill also requires employee training and involvement of employees and their representatives in creating SVAs and SSPs. The bill creates strong whistleblower protection and protects against illegitimate use of background checks. These protections are not present in the current regulations, and might I say that it also ensures the protection for any employee in the business of chemical security, the protection of that chemical security through the appropriate insurance that employees are vetted. It is already covered in the bill in a very adequate and appropriate manner that ensures the competence and the security of those facilities. These changes will not alter the fundamental functioning of the CFAX regulation, and for this reason should not cause any disruption in October 2009. We have used an open bipartisan process inviting input from the chemical sector, water facilities, environmental concerns, state governments, and the department, and will continue to do so as we move forward. Let me acknowledge that my distinguished ranking member and myself have a full commitment, along with Chairman Thompson, the ranking member of the subcommittee and myself, and the ranking member, I assume, of the full committee, along with Chairman Thompson, to have as open a process as possible. This is a committee print of the subcommittee. We look forward to meeting with all of the parties that I just mentioned, even as we go into the full committee markup. I invite individuals to visit with me, and I know that the ranking member will do so as well. What we want is safety and security, but we want to save lives. Chemical facilities are now closely involved, are closely located in urban areas and rural areas where people live. Therefore, it is our obligation and our duty to ensure the safety of those who live in the area and to avoid the tragedy of India, where people are still dying because of the release of that toxicity into the surrounding areas. It is important to continue to press on so that Congress and this committee fulfills its responsibility to guide the Department's regulation of chemical facility security, and we intend to do so. Now I recognize the ranking member of the committee, the gentleman from California, to make his opening statement. Mr. Lundgren.
Thank you very much, Madam Chairwoman. I thank you for today's markup. Today's bill looks very familiar to many of us on the panel. Almost 2 years ago, on a bipartisan basis, our committee drafted and considered H.R. 5695. At that time, I introduced the bill for myself and a number of other members, including the gentlelady who is now the chairwoman. At that time, the Department of Homeland Security, as you noted, had no authority to regulate the chemical industry from a security standpoint. As their authorizing committee in Congress, we recognized that there were great disparities in security across the chemical sector between those facilities that had voluntarily taken action and those that had done very little, if not nothing. Our bill was comprehensive and bipartisan, and it formed the basis for the later chemical security compromises, which were included in Section 550 of the DHS Fiscal Year 07 Appropriations Bill. This appropriations bill, signed into law in October of 2006, granted the Department of Homeland Security historic regulatory authority over the security of chemical facilities. In the 15 months since the passage of that act, the Department, in my judgment, has made great strides in developing and implementing regulations that will require the implementation of security plans at thousands, not hundreds, but thousands of facilities. As a first step in this process, DHS required tens of thousands of facilities to complete the top screen assessment. The top screen provided DHS with some preliminary information regarding the facility's location, the types and amounts of chemicals stored, and the types of consequences that might occur should the facility be attacked. The deadline for submission of this information to DHS was yesterday. Reviewing approximately 50,000 submissions over the next 2 months, DHS will place these facilities into risk-based tiers. And as we've discussed many times on this committee, in the full committee and the subcommittee, risk-based analysis and a risk-based strategy and tactics probably give us greatest bang for the buck. And we are following through, the Department is following through in that same vein. These tiers will form the requirements for those facilities' security measures, including vulnerability assessments and security plans. By the end of this year, hundreds of these facilities will have completed these documents, and the first teams of chemical facility inspectors will be heading out across the country to begin inspecting facilities to ensure compliance. In just 2 years, we will have gone from no regulatory authority, no national cohesiveness or baseline in terms of chemical facility security, to a functioning, hard-lined regulatory scheme focused on securing high-risk chemical facilities. From testimony received last year at 2 oversight hearings on these regulations, and in the dozen briefings staff has received, we have learned that these are meaningful security measures that will significantly reduce the risk of a terrorist attack. So, we meet today in the midst of the Department's Chemical Facility Security Regulatory Rollout Program to consider new chemical facility security legislation. While the committee print does resemble the bill we considered 2 years ago, I have some concerns, and industry has raised some additional questions regarding the inherently safer technology, IST approach, background checks, and information security provisions. Because of the sunset clause included in Section 550, Congress does need to revisit the Department's regulatory authority by no later than October 2009. However, the caution I would have is this: it's imperative that in considering new legislative change, we first, as they say, do no harm. Since the regulations are just being implemented and the chemical industry is making significant capital investments in order to comply, I believe we should do nothing to impede or obstruct these important chemical security regulations. I mean, this is the crux of the problem. If, in fact, we now have many of the players, if not all of the players in the chemical industry, on the verge of committing to capital investments that are consistent with their security plans, I hope we do nothing that would be inconsistent with what has already been drawn up by the Department, what is already legislation, such that we would inhibit the actual introduction of these capital expenditures and other security measures that would be taken by these companies. So as I understand it from the gentlelady's statement this afternoon, as well as from private conversations we've had, as well as her indications of the intention of Chairman Thompson, this is not considered the completed product, and that we know and we will work to make changes in this between now and the full committee, and that we invite, and the chair lady has specifically said to me, that she invites the full participation by members of industry, including personal meetings with her office and my office and our committee staff, and that is not only to be indulged, but it's to be encouraged. And I understand that is the gentlelady's commitment at this time.
Mr. Ranking Member, it is that, and we look forward to an open process. We think the committee print stands on its own legs as a very important document, but comprehensive document, but no legislative process is complete until all parties have had an open opportunity to participate in, and I do, on the record, indicate that that will occur in this subcommittee.
I thank the gentlelady for that. I know we all share the same goal, that these are important facilities and they continue to provide their valuable chemical products to our economy, while at the same time we want to remove a potential target for adversaries who seek to do us harm. And with this in mind, I hope we can work together in a bipartisan fashion to achieve permanent chemical facility security with as little disruption as possible. And again, I underscore, let's not interfere with anything that is going forward now. I want these chemical facilities to be secure sooner rather than later, and I want those capital investments and improvements that are necessary consistent with the law that currently exists. And I thank the gentlelady.
Let me thank you, and obviously this committee intends to move forward in that appropriately bipartisan manner. Let me acknowledge my colleagues who are present. Mr. Markey of Massachusetts, Ms. Eleanor Holmes Norton of the District of Columbia, Ms. Clark of Brooklyn, New York, Mr. Perlmutter of Colorado, and Ms. Jenny Brown-Waite of Florida, Mr. Billarakas of Florida, and Mr. Brown. Why do I have you in? No, I didn't. I started with Ms. Jenny Brown-Waite of Florida. Mr. Billarakas of Florida, Mr. Brown of Georgia. Right. Okay. I hadn't gotten to you yet. Okay. You heard Brown over here. I would never forget Georgia. Please don't. All right. I would like to remind the committee that other members may submit opening statements for the record. I now call up the committee print. The committee print was circulated in advance. Without objection, the first reading of the committee print is dispensed with, and it is open for amendment at any point. Per my agreement with the ranking member, the committee will use a roster for amendments today,
Reserving the right to object, and I will not object. I would ask the chair to explain our agreement concerning the amendments.
Thank you, Mr. Ranking Member. The committee will first take up amendments in the order listed on the amendment roster. If a member is not present to offer an amendment that is listed on the roster, the committee, the chair will allow the member to offer the amendment when the member returns, to the extent practical and not prohibited by House or committee rules. Finally, amendments that are not on the roster may be offered after there has been an opportunity for amendments on the roster to be offered, to the extent practical and not prohibited by House or committee rules.
I thank the chairlady for explaining our agreement on procedure, and I withdraw my reservation.
As stated earlier, we will start with amendments listed on the roster. I have an amendment on the roster. The clerk will report the amendment.
Amendment to the committee print offered by Ms. Jackson Lee of Texas. Strike the proposed section.
Without objection, the reading is dispensed with. I now recognize myself to briefly explain the amendment. My amendment would improve the bill in two ways. First, it would ensure that DHS undertakes a robust search to fill the director position at the Office of Chemical Facility Security with a career federal service employee with the qualifications to get the job done. In less than 1 year, DHS will face a serious test. For the first time ever, it will go through a change in presidential administrations. Hurricanes Katrina and Rita taught us that it is critical to have competent leadership in time of crisis. With the upcoming change in administrations, it is all the more important that DHS has qualified career professionals at critical posts throughout the department. We've all celebrated the fact that the United States has been blessed by not having had a terrorist attack on its soil. But yet we can look around the world and look at the landscape of terrorist acts and understand that we must be prepared. I don't believe we are prepared without a competent person in the position of which I speak. Under the leadership of Chairman Thompson, this committee is focused on the need for qualified, diverse leadership at DHS. In fact, in the Post-Katrina Emergency Management Reform Act of 2006, we created new requirements for management at FEMA to ensure that the agency is up to the job. In that same spirit, this amendment would ensure that the Office of Chemical Facility Security is headed by a director who is a career civil servant and has the necessary knowledge, base, and skill sets to execute this critical role of ensuring that our nation's chemical sector adequately addresses the threat of terrorism in a post-9/11 world. Specifically, the director of this office should have an intimate knowledge of physical infrastructure protection, cybersecurity, facility security, hazard analysis, chemical process engineering, and chemical process safety reviews, as well as other qualifications determined by the Secretary. The current head of the Chemical Security Compliance Division, Mr. Larry Stanton, is just such a qualified person. We applaud the department for seeking out such a person for this important position and wish to ensure by this amendment that this position will always be filled by a qualified individual. Political connection should not be the requisite for serving as the director of the Office of Chemical Facility Security. With this amendment, we can assure that there is an experienced hand guiding the office and the department through the upcoming transition and beyond. Moreover, my amendment would further require that the Secretary consider a diverse pool of applicants, thereby broadening the base of skills and experiences. It should also have a very good record of attracting and hiring diverse managers at the senior executive level and above. My amendment also requires the Secretary to alternatively seek out a qualified individual from among the group of applicants that are diverse, or that is diverse according to race, ethnicity, age, gender, and disability characteristics, and report the selection process and findings to this committee and the Senate Homeland Security and Governmental Affairs Committee in order for us to engage in proper and responsible oversight. The second way that my amendment will make the underlying bill better is by requiring the department to develop and disseminate information on best practices to the chemical sector to make them aware of best practices used by other appropriate members of the sector or other sectors where appropriate. Why not utilize a virtual fence? Let us make sure that we have all of the best technology to ensure security at chemical facilities. The regulations described in this bill are performance-based rather than prescriptive and therefore do not require facilities to implement specific measures. This provides companies with the flexibility in implementing what they feel are the best measures in order to secure these facilities. Because this bill builds on the current CFATs, pronounced CFATs, regulations, it provides predictability to all relevant entities, the private sector and the government. Like the CFATs regulations, this bill takes a risk-based approach to chemical security. It allows companies to implement measures that are effective from both security and cost perspective. We expect the department to be helpful as we move these legislative initiatives forward and be helpful to the chemical sector as much as possible to achieve our common goal of security measures. And we want the department to share best practices in meeting security measures with regulated facilities. These practices should allow companies to analyze, modify, and implement previously implemented measures that have been utilized by similar companies and to do the best and use the best possible methods for ensuring the safety of those and security of those facilities. Taken together, I believe that this amendment improves the underlying legislation. I urge my members or the members of this committee to support it. Is there any discussion at this time? Mr. Lundgren.
I thank the
recognized for 5 minutes.
Chairwoman, and I will support this amendment, but I would have a couple of concerns. I'm not an expert on civil service laws. And I think the qualifications you have in here are appropriate qualifications consistent with what is already the intent of the bill. My only concern is this: by saying that it has to be a career civil servant, do we eliminate the possibility of an outstanding academician, an outstanding scientist, an outstanding person in the industry who now would like to do some service here that might provide the best leadership for that job, but is not a career civil servant? In other words, I would not make it required that it be a political appointee, but I just wonder if it makes sense that we require it to be a career civil servant when perhaps the best unique person for that is someone who's not spent all his life in government. And that is a concern I would raise. And hopefully we can look at that, because again, I don't know how difficult or easy it is to have someone like that come into civil service for a job for 4 years or 3 years or 2 years. But if that's the best person for the job, I'd like to be able to reach out and get that person. So hopefully we can talk about that on the way to the full committee. And with that, I'd yield back the balance of my time. I'll be happy.
The gentleman would yield. The gentleman makes a very valid point. We are striking the balance in the manner that we have struck the balance to ensure that we do have a qualified civil servant. However, you made a very good point about looking at this as we move toward the full committee, and I can assure you that we will do so. We certainly want this to be inclusive and not exclusive. We think by the civil service structure it is inclusive because an individual of that competence could certainly come into the civil service process. But I assure you that we will look at your concern and take it seriously as we move toward full committee.
Thank you, and I yield back the balance of my time.
Gentlelady from District of Columbia is recognized.
I don't read this to, and again, it does need clarification on what was intended. I don't read this to mean that the person is already a member of the career civil service. If a person it comes in as SES, comes in very differently from if he is still called Schedule C. So I do think this needs clarification, and frankly, I agree with the ranking member with respect to somebody who has no political history, might be appointed, but, and here I need to know more about SES, would come in essentially as a civil servant, but this language leaves open whether the person already has to have been there, which I'm not sure we really meant, or whether it means once there. He is not a political appointee, but is a civil servant.
Well, the gist of the amendment and all of the members' comments, I'm sorry, if the gentlelady would yield.
I'm glad to yield, of course.
All of the members' comments are taken advisedly under advisement, and we will assure you that we will clarify. The idea is, of course, to have a non-political appointee, but we will work with the language of Schedule C and under, because I know that to make sure that your concerns are taken into consideration so that we're not barring someone with experience, but that we're making sure that it is on experience and credentials as opposed to anything else. And I yield to yielding back.
Yeah, because I want to say very often the way in which one searches for positions of this importance is a nationwide search. So
Absolutely.
It should mean that whoever's in the civil service should have to compete with whoever's out there, so long as they don't come with some kind of political baggage.
If we can move this amendment forward, I can assure you as the chair of the subcommittee that we will clarify that language and share that with members. You yield back?
I'm pleased to yield back,
Thank
Mr.
you.
Chairman.
Further discussion? Hearing no further discussion, the question is on agreeing to the amendment. Those in favor say aye. Aye. Those opposed, no. No. In the opinion of the chair, the ayes have it, and the amendment is agreed to. All roster amendments having been considered, are there any further amendments?
Madam Chair, I have an amendment.
For what purpose does the gentlewoman from Florida seek recognition?
The amendment is at the desk, and I would ask for 5 minutes to be able to discuss it.
The clerk will report the amendment.
Amendment to the committee print offered by Ms. Brown-Waite of Florida. After the proposed section 2115, insert the following new section. Section 2116.
I ask unanimous consent to waive the reading of the amendment. Oh, you're supposed to ask that.
Well, either one of us can. Either one of us can, but certainly it would be helpful to waive the full reading of the
Great, and
amendment.
I'm saying without objection. How about that?
Sounds good.
I'm just trying to move fast for people's airplanes. I'm sorry. The gentlelady from Florida is recognized for 5 minutes to explain her amendment.
I thank the chairwoman. My amendment would ensure that those working in high-risk chemical facilities do not pose a threat to our nation. America's chemical facilities are a critical element of our nation's infrastructure. As we are all aware, if terrorists were able to exploit weaknesses in security at chemical plants, especially those deemed high risk, there could be very far-ranging disastrous results. The failure to mandate background checks on employees in high-risk facilities is probably this legislation's most glaring weakness. Any effort to regulate chemical facility security must require meaningful background checks of those working in such a critical position. My amendment would require that employees working within these most critical infrastructure facilities must pass screening against the terrorist watch list and immigration status databases. Mandating this screening would simply mirror the requirements that are already placed on all aviation and airport employees, all port workers, and all commercial truck drivers. Certainly extending this security measure to those working in high-risk chemical facilities is a very simple, common-sense approach toward stronger security for our nation. Madam Chair, I yield back the balance of my time, but I do know there are other members who would like to speak on this.
Has the gentlelady yielded back her time?
Yes.
Thank you. I recognize myself for 5 minutes. I thank the gentlelady from Florida for bringing up this issue, and I know that many members are contemplated. It is an important security question to thoroughly vet those who will be working at the nation's high-risk chemical facilities. That said, the concerns that I have as chair is that it is a new topic that has not been explored in this subcommittee to date. For example, this was not an issue raised at the December hearing on CFATS regulations and this draft legislation. There is also a concern as to the jurisdictional question, and therefore we are considering the concerns about the amendment in light of the fact that it has not been brought up before. We do not know yet what industry and relevant advocacy groups think of this measure, and we would want to be able to consult the department. So my concern is the idea of trying to make the amendment, if you will, whole by having it fleshed out and making sure that it meets all of the jurisdictional concerns. With that, I'm going to reserve or at least yield back my time and recognize, is there any, is it your hand up? Recognize the ranking member, or you?
He can speak first.
Recognize Mr. Brown for 5 minutes.
Thank you, Madam Chairwoman. I support Ms. Brown-Waite's amendment, which would require high-risk chemical facilities to conduct background checks against the terrorist watch list and the immigration status database for their employees and those seeking employment. This is a common-sense amendment that has been implemented in many other sectors of critical infrastructure. This background screening would mirror the requirements for all aviation and airport employees, all port and maritime workers, all commercial truck drivers, and all rail and mass transit employees. I know that everyone here wants to protect America from another terrorist attack, and it seems to me that not requiring background checks in high-risk facilities is a significant loophole in this draft legislation. On the issue of the larger bill itself, I'd like to associate myself with the concerns that Mr. Lundgren expressed during his opening statement. I'm sure that the majority of this committee would agree that DHS is making excellent progress identifying our high-risk chemical facilities and implementing security measures at those sites. However, DHS has not had an opportunity to provide comments and feedback about the actual effects of current regulations, intentional or otherwise. I think that we need to ensure that any new legislation is not going to disrupt the ongoing work of DHS to secure chemical facilities. I hope that we can work together in a bipartisan manner to review the department's comments and make all of the necessary changes before the full committee markup. Madam Chairman, I yield back.
I thank the distinguished gentleman. Let me yield to the ranking member from California, Mr. Lundgren.
I thank the chairwoman for allowing me to speak on this. I would rise in support of Ms. Brown-Waite's amendment on a couple of points. One is the gentleman from Massachusetts has been a leader in telling us how important it is for us to try and get the chemical facilities under the ambit of DHS and with a real regulatory scheme with respect to the inherent dangers in a very vital industry. I think he has made the point more than one occasion that this is just as important as the airline industry or anything else. That being the case, Ms. Brown-Waite's amendment attempts to try and have equal treatment, not for all chemical facilities, but I believe she, in her amendment, has limited it to merely the high risk, and I think that would be Tier 1. And so what we have done here is tried to say the same kinds of background checks that we think are appropriate with aviation, airport employees, port and maritime, commercial truck drivers, and rail and mass transit employees is appropriate here. In other words, it's an extension of the thinking that this subcommittee and full committee has followed in the past, where we've recognized an urgent need for a security regime over different elements of our economic structure and infrastructure. And so for those reasons, I think it would be important for us to move forward. Now, I would presume on this amendment, as well as the full bill that we have before us, there's work that can be done between here and the full committee, but I would hope that we would not reject the notion that this is appropriate. And interestingly, as I read it, the amendment does not change the appeals process that we find throughout the regime that we have, but rather fits into that. So any concern we have about a particular individual being placed in a bad position on erroneous information ought to be alleviated by the appeals process that's already part of the law. And so recognizing that probably work needs to be done on this amendment between now and the full committee, I would hope that we would at least support this concept at this time and have it incorporated into what we are attempting to do.
Will the gentleman yield?
I'd be happy to yield.
Let me pose a question to both the ranking member and the distinguished gentlelady from Florida. You heard my comments. It was comments about hearing precedent, but it was not comments to suggest opposition. I would ask the gentlelady for her indulgence to withdraw this amendment at this time. I already have an agreement with the ranking member that there's a lot of work that will be done as we move toward the full committee print markup on this particular legislation. I'd like to be able to work with her and her staff and our committee staff if she would be kind enough to withdraw it at this time and to indicate that the four corners of her amendment has certainly a support on this committee. We just want to be able to investigate the language and investigate whether you put Tier 1 versus high risk, et cetera, and some other elements. Would the gentlelady be kind enough to withdraw for us to work with you?
To the gentlelady on my time.
And I know that the time is running out. I'd like to see this proceed in the bill, because I think that very often as the bill goes on, and I believe it's going to at least one other committee, that sometimes these things kind of get lost. I think it is appropriate that we have the same safeguards here as the other entities where these background checks were required, such as aviation and airport employees and port workers. So I really would like to see this continue in the bill. There will be other amendments, as you know, before the bill actually goes to the floor, and I hope it will go to the floor. I think it's a good bill.
Balance my time.
Thank you. You're reclaiming your time, and it's over. Yield it back. Let me recognize the gentleman from Colorado for 5 minutes, Mr. Perlmutter.
Thank you, and I've generally supported the Congresswoman from Florida on these kinds of amendments, but I'm particularly concerned by this one because we have had, I don't know how many hearings on the fallibility of the terrorist watch list and these immigration databases. And although I generally would like to take the ranking member's word for how this is integrated with the redress process, I don't see anything within this particular amendment that gives any appeal right to anybody who's been tarred by these lists that we know have trouble. And as much as I want to support the intent of where you're going here, I don't think that you finished this amendment, and I'm not going to support an amendment that's half finished.
Would the gentleman yield?
Yes.
I appreciate that. It does not affect the appeals process provisions in the rest of the bill. The base bill has several specific requirements regarding appeals and waiver process for any background check required under this title. It doesn't affect the language that was put in the bill by the majority. It only specifies that high-risk chemical facilities must complete these background checks. And the gentlewoman from Texas, our chairwoman, had mentioned, you know, the terrible accident in India. We don't want that to happen here, and I think this is one way that we can make sure that the chemical facilities are safe. But by the way, Mr. Perlmutter, before I yield back, it is covered in Section 2115 under security background checks.
2115.
Yes.
And the gentlelady.
Page 56
and,
of the bill.
If I might, Madam Chair, so you don't think that within your amendment you need to refer to that section? I mean, that's what's bothering me. And it may be belt and suspenders, but this is, when you now refer to the terrorist watch list and you refer to immigration status databases, and I'm not really sure what those are. I think that's actually new language that I don't know that I've seen in other kinds of legislation that we've done here. I'm just particularly concerned that we don't tar somebody with one of the mistakes in those lists, and we've just had too many hearings that have caused me a lot of concern, particularly on the terrorist watch list.
Will the gentleman yield?
Yes.
Some of the chemical facilities also have individuals who are on legitimate visas. The language here says that a person cannot work there if they are not a legal resident. We want to be secure, but I might imagine some of the individuals in your constituency, obviously they may not be legal residents, but are on legitimate work visas, maybe of the professional level visa, and so that's why there needs to be more expanded work on this amendment. I'm sorry.
I'll yield back. I've stated I'm happy to work with you on this and to do maybe what you might consider to be belt and suspenders by putting additional language about a redress process within this section.
Would the gentlelady allow, I'm sorry, would the gentleman yield? Could we perhaps have staff work on some language that would say anyone who is here legally?
Well, is the gentleman,
you know, who may be here working at a plant.
will the gentleman yield? The gentleman yield?
Yes.
Then could I again request a withdrawal of the amendment for us to be able to work on language as we move toward the full committee of the gentlelady from Florida?
I would ask the gentlelady from Texas if it doesn't appear in here when it goes before the full committee in an acceptable manner, I certainly would appreciate your help in the Rules Committee, because I think that this is a very, very important safeguard that we need to give to all of the neighbors living around any kind of a chemical plant.
And I think it's my time, and I would claim my time back. And
I
would
reclaim your
say
time.
I don't disagree with that. I just like to see us do it in a polished, more polished manner. And I don't, you know, make myself out to be the, you know, the great, you know, writer of these things. But I think there's some additional things that could improve this a lot.
Would, the gentleman's got 5 seconds, would he yield? I think that's what markups are for. We have this so that we can work through amendments that will make the bill certainly a better bill for every American.
The gentleman's time has expired. Hearing no further amendments, the question is on agreeing to the committee print as amended. All those in favor say aye.
Madam Chair, I didn't withdraw my amendment.
No, I'm moving for a vote.
Okay. I thought you were voting the commit.
No, we're voting on the amendment. Your amendment is.
Oh, okay, okay.
Hearing no further discussion, the question is on agreeing to the amendment offered by the gentlewoman from Florida. Those in favor say aye. Aye. Those opposed, no. In the opinion of the chair, the noes have it. The amendment is not agreed to. And a recorded vote is requested. And is there sufficient second for recorded vote? It is, look up, you've gotten recorded vote. Sufficient number having agreed, a recorded vote is ordered. The clerk will call the roll.
Mr. Markey? Mr. Markey votes no. Mr. DeFazio? Ms. Norton? Ms. Norton votes no. Ms. Clark? Ms. Clark votes no. Mr. Perlmutter? Mr. Perlmutter votes no. Mr. Lundgren?
Aye.
Mr. Lundgren votes aye. Ms. Brown-Waite?
Aye.
Ms. Brown-Waite votes aye. Mr. Bilirakis?
Aye.
Mr. Bilirakis votes aye. Mr. Brown?
Aye.
Mr. Brown votes aye. Mr. DeFazio? Ms. Jackson Lee?
No.
Ms. Jackson Lee votes no. Madam Chair, on that vote, there were 4 yeas and 5 noes.
The noes have it, and the amendment is not agreed to. I think we have concluded the hearing, and hearing no further amendments.
Madam Chair.
Let me recognize the distinguished gentleman from Massachusetts, Mr. Markey.
Mr. Chairman, Madam Chair, I just want to be recognized to praise you and to praise the gentleman from California for the excellent job that you have done, and I just wanted to be recognized for the purpose of making that point. There are nightclubs in New York that are harder to get into than chemical plants across this country, and this bill goes a long way towards solving that problem. I yield back the balance of my time.
If I might, Mr. Markey, if I yield myself, that should be the singular defining moment of this hearing, that one comment. Nightclubs in New York are harder to get in than chemical facilities. I thank you for your kind words. Let me recognize Mr. Lundgren.
Could I strike the requisite number of words? I won't.
Gentleman is recognized.
First of all, obviously, the gentleman goes into tougher neighborhoods than I do for his nightclubs. No, I didn't say anything about your district. But of course, he did go to B.C. I would just like to put this note on the record, and that is, Mr. Markey and I had worked out a compromise with respect to the IST 2 years ago, which I thought was workable. This appears to be based on that, but there's additional language here that I hope we would have a chance to review before we get to the full committee. I've spoken with some in the industry who believe that it may not be in the most workable form. The ones I've talked to, I do not believe we're trying to get out from under the regulation, but rather I hope that we will, in our both individual capacities and our committee staff, work together to see if we can refine this with respect to some legitimate issues that I think have been brought up by the industry in the last couple of days when we've seen the language. And so with that, I would yield back the balance of my time.
Let me, as I bring the hearing to a close, indicate again, Mr. Lundgren, that I think members are open to insight from the industry and others and particularly members of this committee who work so hard on these issues throughout their career. Hearing no further amendments, the question is on agreeing to the committee print as amended. All those in favor say aye. Aye. All those opposed say no. In the opinion of the chair, the ayes have it, and the committee print as amended is agreed to. Without objection, the committee print as amended is recorded or reported to the full committee. Without objection, the staff is authorized to make any technical and conforming changes, and the committee stands adjourned. Thank you.
Do you have any idea when we might get this to the full committee?